here's what's going to happen. We're going to finish up Mel Frank. We're going to talk about and finish up modification. We may even get into third-party beneficiaries. That's the goal. So we've got about 40 minutes to do all of those things. So we'll see how we do. Okay, so Mel Frank finishes up our conversation about impracticability, impossibility, frustration of purpose. I don't know why I think it's the free-flowing feel of the room or what's happening tonight, but I guess I'll tell you 10 out of 10 times Professor Cummings tests on impossibility, impracticability, and frustration of purpose on midterm exams. So a couple things that are really important for you to know. What are the difference between them? Under what circumstances can you plead them? And I, unlike the Waddy versus Riggleman case, still think impossibility is differentiated from impracticability. So even though Justice Davis in Waddy versus Riggleman kind of puts them together, I still think impossibility is a different doctrine. I have a couple of those. A different doctrine than impracticability. Make sure I see that. Okay, and Mr. Hale, Mel Frank, remind us. Pull us back into the frustration of purpose place.
I remind myself too. So Mel Frank is the landlord of these premises, and Dichem is a chemical company. They signed a 3-year lease to store chemicals. However, they never mentioned that they were going to be storing hazardous materials, nor what percentage of their goods is hazardous. So that became an issue when the city put forth a ordinance that said you couldn't store hazardous materials anymore in the certain way they were. And so they wanted to get out of the lease because their purpose was frustrated by the city ordinance.
Okay, good. Was their purpose really frustrated by the city ordinance?
But the court said no. The court said
What does Mr. Hale say?
No, absolutely not.
Okay.
For one, they never mentioned hazardous materials up front. They never put it in the contract, and all of their materials were not hazardous, so their entire purpose of the contract was not frustrated.
Okay. Why not? What could they have done alternatively?
Well, they could have brought the building up to code and still stored them up to code with the ordinance, or they could have they could have mentioned up front that there were hazardous materials, or told them what percentage of their lot was.
Is it possible, this is for all of you, is it possible that folks would use, are you not going to follow me?
Hands to the left, hands to the right. We have one still shot, sir.
Is it possible that folks would use frustration of purpose or impracticability to try to breach contracts that they shouldn't?
Yes. Everything is possible.
Everybody is so honest. I really don't think so.
So if, in fact, we're trying to use frustration of purpose here to breach a contract, what would motivate that? So your your Dichem, what's motivating your use of frustration of purpose to breach a valid lease that you'd entered into?
Profitability.
What do you mean?
It would no longer be profitable for them to bring up to code, or since they couldn't store most of their materials, as they put it, that's not profitable for them anymore. They'd have to sign a separate lease to store those. So.
Okay, good. Let's. What's our frustration of purpose restatement section? Mr. Hale or anybody? Where are we for frustration of purpose?
265.
Okay, 265 is our frustration of purpose restatement section. In walking through it, Mr. Hale, we'll walk through it together. Where did Dichem fail? So together, where after a contract is made, a party's principal purpose is substantially frustrated without his fault by the occurrence of an event, non-occurrence of which was a basic assumption on which the contract was made, his remaining duties to render performance are discharged, unless the language or the circumstances indicate to the contrary. That's very similar, guys, to the impracticability section. You can break that basically down into 4 elements. Where does Dichem fail in this test?
I didn't bring my sidekick with me, but I do remember that they didn't. It
This is
wasn't
the sidekick.
a substantial purpose. Yeah, it wasn't a substantial purpose of their contract for one.
Okay.
It wasn't the principal purpose of the contract because it wasn't even mentioned in the contract for another. And could you remind me of the other two elements?
Yeah, where after a contract is made, a party's principal purpose is substantially frustrated without his fault, his or her fault.
Yeah, that was the other. It was their fault. They didn't bring it up to code. They knew it. They changed the premises to so it wouldn't be up to code with that.
Okay, we have a dissenting opinion, Mr. Vega?
Well, I don't think what the responsibility could be to bring the building of the code. It was the person leasing the building.
It was up to code up front, and they changed things that didn't make it up to code any longer.
So the
They actually-
city changed ordinances.
Right,
Yeah.
and they actually had to give up damages because they changed the premises and damaged it that way.
But what do you think that the people in the building changed the
No.
building?
The people that were renting,
Yeah.
the leases, yeah, they changed it.
I thought it was the city that changed the ordinance.
It's both. It's both.
So, importantly for our purposes is the element of without his or her fault, right? So it cannot be the fault of the individual upon whom they're trying to claim frustration of purpose. That's the whole Waddy versus Riggleman case, the attorney hours. That's what permeates the elements, is that it cannot be the fault of the individual that's seeking the out, the impossibility or the frustration of purpose. If it is, no work. It doesn't work. Here, it sounds like it could be arguable whether or not it was their fault. But the important points here is it was most likely not an occurrence upon which an event, the non-occurrence, which was a basic assumption on which a contract was made. And at the end of the day, the ultimate holding of the court is the purpose wasn't really frustrated. They could still they could still abide by the lease. They just needed to move their toxic chemicals out, or hazardous chemicals. They could have still fulfilled the lease, so it wasn't really frustrated. So that's the Mel Frank sort of take on frustration of purpose. Walkaway points. One is that you will see individuals try to get out from under contracts that they're validly entered into with the doctrines of impracticability, frustration of purpose, and impossibility. So you have to be careful and watch for that to see whether it is truly impossible. The impracticability element is whether market fluctuations have made it undesirable versus impracticable. What's our scale there? What are we looking for when we're talking market fluctuations, changes in market versus impracticability? Mr. Vaughn?
10 to 12, sir.
10 to 12 what?
10 to 12 times the expected difficulty.
Okay, good. So there we're looking at significant financial burden, right? Because why? Mr. Bissell, why? Why do we want it to be a significant financial burden and not just a market fluctuation that makes the contract less appealing?
Everybody be trying to get out.
Everyone will be trying to get out. And what are contracts supposed to do in the first place? Especially crops contracts and land contracts. What are they trying to do?
They don't keep them.
Say it again, Michael?
Guard against risk.
That's what contracting is about. We're trying to protect against risk. If you decide on a price for a year, you know it can go bad, up and down, on either side. You're trying to mitigate risk in contracting. So market fluctuations don't work. It's got to be significant for impracticability to work. Key for impossibility, you're usually looking for death or destruction or no longer existence. That's sort of not a frustration of purpose or an impracticability. You could make it work. The impossibility is this person isn't alive, or this building doesn't exist, or this land is no longer there. Okay? Impossibility, frustration of purpose, and practicability.
If Dychem was more careful in their lease wording, like specifically putting in the phrase that they were leasing this exclusively for the storage of hazardous chemicals, would it have been easier for them to get out of this?
Yes, absolutely. So what broader point am I about to make? Read my mind. What am I about to say about Wetzel's question about the terms of the contract?
Pay attention. Be specific.
Say it.
Pay attention and be specific.
Who will be in charge of these contracts?
Us.
You will be drafting contracts. You will be drafting the terms and the language. You've drafted a few already, at least one, for a screenwriting team. You will be drafting these terms. I can't tell you how, hundreds, maybe in the thousands of contract terms I've read, or I've negotiated, or I've drafted. And you're trying to think through all contingencies. That lawyer should have thought about their toxic chemicals in drafting that lease. Maybe purposely didn't. Maybe trying to let them out.
Well, I
Storms.
think probably they purposely didn't tell them that our store has it.
So they deliberately hid it.
Because usually people who deal in toxic chemicals and storage of toxic chemicals and stuff like that, it's a lot more expensive to lease that property because it has so many restrictions for how it has to be stored and the buildings and the security and all that.
Okay, right. Sign-in sheet, which did not migrate over here with me from the law school. Wednesday, you'll sign in for both days. So I'll pass it around on Wednesday. Just remember to sign in for both days. Good. Modifications. Mr. Diaz, the law feels how about modifications? Fill in the blank. The law, blank, modifications.
Law supports modifications.
The law
Supports.
supports. Why? Mr. Diaz, why? Why does the law support modifications? What's the policy? Generally speaking, why would the law support modifications, Ms. Lindahl?
To keep businesses humming.
How much does contract law care about economies humming?
Very much.
We wrote a whole freaking code about it. The UCC is about economies humming. How much do we care about that in the United States? Small businesses, American dream. That's our thing. No? It's kind of our thing. Like, we care about it. So we support modifications to help business flow. You got something, Mr. Diaz?
It's common law versus UCC.
So common law versus UCC matters when it comes to modifications a lot. Mr. White? Mark?
Here's the party's intent.
We really, really care about parties' intent, and we want parties to get to the place they want to be. So if they want to modify a contract they've entered into, please do. We want you to modify the contract so that it matches what you intended. But we don't want, legal term, shenanigans or games with these contract terms. So we don't want to allow people to modify contracts if both parties don't mean it, or if you're trying to hold someone hostage, a la Alaska Packers, maybe. We don't want people to threaten by not performing, but if it makes sense under the UCC or to keep business flowing, or in common law, we want people to be able to modify their contracts. Mr. Baker. Ms. Washington has taken your place as the class recorder tonight. So, thank you, Ms. Washington. Mr. Diaz, difference between common law and UCC in connection with modifying contracts.
Right. So the UCC modifications are upheld in their respective versus in common law.
Do modifications under the UCC have to be written? Do modifications under the UCC have to be written?
Under.
We have a divergence of opinion.
It can be oral or written.
Okay, we're talking about oral modifications under the UCC.
If it's more than $500, it needs to be
If
in
someone
writing.
relies upon it, or they continue acting with the modifications upheld, then they're allowed if they were oral.
Okay, say it again.
If the parties rely on the modifications and they keep their dealings acting as if the modifications have already been made and upheld, then they will be upheld in the court.
Don't have to be written down?
Not via Brookside v. Mama Rizzo's.
Your notes say?
we did something with, statute of frauds and something,
It is not
modification, that's something to do.
Mr. Baker,
Basil.
are we in a conundrum? Mr. Baker?
If your modification is gonna put the contract back to the statute of frauds.
If your contract is going to take your agreement into the statute of frauds, then it has to be written. So that's what Diaz is talking about. That's what Baker's talking about. What about an existed written contract for more than $500 and you change it all the freaking time? As happens in business, you change the order number, you change the price, you change the delivery date. Do they have to be written down? That's the resounding no I'm looking for.
Unless there's a merger clause.
Unless there's a no oral modification clause. Okay, step us through that, Ms. Steeritz. Step us through that. So this is where we're at. If a contract is over $500 for a sale of goods, it must be in writing. And if you take a oral modification above the 500 threshold, that must be in writing. If you have a written contract that you're constantly orally modifying, that is accepted, that is expected, that is anticipated, that is no problem under the UCC. Under the UCC, we live with oral modifications, no problem. Why is that? Policy reason?
Keeping business
Ms.
going.
Cope?
Gotta keep business going.
Got to get business humming, best we can. Okay, now walk us through the no oral modification.
So a no oral modification clause says modifications have to be in writing. Under the common law, they're generally not enforceable because it restricts parties' right to bargain. But under the UCC, the assumption is you can continue to orally modify a contract. So if parties deliberately decide we're going to say you can't orally modify it, then the UCC is willing to recognize that.
So if I had a whiteboard behind me, I would put a asterisk and a MS for Michael Steeritz on the board. Then I would also put another asterisk for SM, Sean Moody, because dude set our classroom up for us tonight. So thank you, Sean. Give him a hand, please. Otherwise, y'all would have been setting up table by table while I was preparing to be videotaped. Leave it. All right, so what Michael said is really critical. I'm going to ask her to try and rephrase it as best she can because this is the most important part of oral modifications right here. Go.
Which part?
The whole thing.
The whole thing? So no oral modification clauses that say that you cannot modify a contract orally usually aren't upheld under the common law because they restrict parties' rights to continue bargaining. But under the UCC, since the assumption is that you can continue to orally modify a contract, if parties deliberately put in a clause that says you can't orally modify this contract, the UCC upholds that as a deliberate choice.
Comments or questions about that? That is so right and important. Comments or questions? Common law, we're not feeling no oral modification clauses because we want parties' intent to prevail. So we view under the common law as that is some sort of attempt to freeze the intent of contracting parties. So it's generally not enforced under the common law. Okay, the same is true under the UCC. We want modifications, and oral modifications are fine. That's the assumption to keep business humming. And because business persons aren't going to constantly call each other and agree to sign something to change an order or to change a price, we want it to continue. However, if the trouble is gone to put a no oral modification clause into a sale of goods contract, it's going to stop the judge in his or her tracks. And the judge is going to say, oh, well, we typically allow oral modifications, but in this instance, they negotiated a no oral modification clause, so we will respect that. And all modifications must be in writing if under the UCC in a sale of goods contract, you include a no oral modification clause. Okay, I tried to restate what Michael just said. Is that good? Didn't confuse anyone? Ms.
Is
Lindahl.
that common? Because it seems like that nuance is inconsistent with the doctrine underlying PBCC.
Okay, how? How is it inconsistent?
Well, because I think it makes sense under common law for it not to be enforceable because it prevents the party's ability to continue bargaining. And I would think the same is true. Like, I understand if oral modifications are okay, therefore, if you go to the trouble of putting this in, we're going to respect it. It just, A, I wonder how common it is, but B, it just seems inconsistent.
Because I'm having a little bit of a brain freeze. Who started our Brookside Mama Rizzo's pizza case? Please own up to it. Okay, who's done that? Thank you. Every once in a while, especially when I'm in a 100-person class and I ask someone to own up to it and they don't, gets a little troublesome. So to answer Ms. Lindahl's question, how common do you think a no oral modification clause is in a sale of goods contract? Or in other words, was there one present in the Mama Rizzo's pizza case?
That was not, and I would probably say that it's not the most common, I think it's probably more of an irregularity than it is of
Why would business owners not want to place no oral modification clauses in their sale of good contracts? Ms. Dunlap? Why would business owners not want to include no oral modification clauses in their sale of goods contracts? So on the table, we're suggesting it's rare that you have a no oral modification clause in a sale of goods contract. Why?
I would say that businesses, you said why the businesses not want to.
It's kind of a double negative.
So that, you know, once the terms are agreed upon, it's not, you don't have the opportunity to necessarily go back and disadvantage them perhaps.
Okay. Other ideas? Daniel?
If the market changes, then you want to be able to adjust your prices accordingly.
Okay, good. So think about the Nanakuli case as sort of massive market changes. Less massive market changes, you want to be able to orally modify. You want to be able to call someone on the phone and say, whoa, we just had this freeze. Our orange crop is frozen out. We're going to need to adjust. You want to be able to do that without having to redraft a contract, renegotiate, write everything down. Mr. Baker?
I was gonna say, so I don't have to pay you an hour to review or redraft it, get expensive.
You don't have to pay me.
So you don't have to pay them.
To
Pay
redraft
me.
it.
Yeah.
I just heard me. I just heard me. What are you paying me for?
$41, sir.
So you don't want to have to pay your attorneys to get in to the contract all the time and renegotiate and redraft. You know, I was talking to I think it was the Arkansas Cinema Society director, but someone in the last couple of days who was talking about an attorney in town known as a deal killer. That's the name of the attorney. That dude is a deal killer. He will squash your deal. Try and keep him out of any negotiations in connection with, I'm afraid to say it. You want commerce running through this spot, right? You don't want people going away. And again, so that gets to Chris's point about no oral modifications involving attorneys and their billable hours more frequently.
Is email not considered written?
Say it again?
Is email not considered written? I mean, I'm just thinking like this is not such a big deal anymore now that people email back and forth.
Yeah.
Because if I email you and say, okay, I'll pay $1 more, and you like email back and say, okay, that's a written document.
So I'm still thinking though, I could get into trouble because I haven't given this any thought, and I'm afraid that I'm being recorded, but I'm gonna say that the emails are not gonna count as written supplements to the contract. It's actually like in the Mama Rizzo's pizza case, the guy kept saying, I will go back to the contract and write in what we've agreed to do. So I'm thinking,
But it wasn't
I don't know if
in the contract.
emails are gonna constitute oral modifications, but they're not adjustments to the written
So the law
contract.
hasn't actually
I'm sure it has, I just don't know the answer
But wasn't
to
in
that.
the,
Could it be the multiple writers reference in the statute of frauds though?
Yeah. So Jessica brings up the point about multiple writings under the statute of frauds. Think of the Elizabeth Arden case and sort of connecting different things to get to a place.
Right.
So that could be relevant.
I was gonna say the ice cream case from, I shouldn't say ice cream, but the
Mhm.
ice cream owner
Mhm.
case from last semester, that was all basically emails going back and forth.
Yeah. Yeah, good points. Grace.
If the no oral modification clause is part of like a standard boilerplate contract, is that gonna be enforceable typically, or is that gonna be iffy?
Okay, a couple things. So Mr. Vaughn asks if a no oral modification clause is part of boilerplate, right? And now we're talking battle of the forms. Is it going to be so? What is your general sense as to whether a form in a sale of goods contract includes a no oral modification clause? What's a judge going to do with that? Libby?
Well,
Ms.
first,
Nelson?
I highly doubt that these businesses are gonna have that in their forms. If it's such a big deal, I don't think it's gonna be in their boilerplate language, but I have a hard time thinking a judge is gonna, if both parties know that it's just the boilerplate language, then I don't think the judge is gonna hold it.
I tend to agree with that. I tend to think that if you're the lawyer in a sale of goods contract saying let's include a no oral modification clause, you're not going to be employed as the lawyer for that business for a very long period of time, just because it stops business. It's a deal killer. It doesn't help business flow. Secondly, if we're in the battle of the forms, thank you for bringing that up, Chase. I just have such a warm spot in my heart for the battle of the forms. But if you're in the battle of the forms scenario and you have a no oral modification clause, that's surely going to get knocked out, I would think, based on the forms going back and forth and whether or not, that was an anticipated term and all of the sort of permutations that go with that. Okay, so wrapping up Mama Rizzo's Pizza, Ms. Dunlap, I don't love the case. It's complex. It's about stems and basils and all sorts of permutations. But at the end of the day, what does the court do with the failure to include the uptick in price per pound in the written contract? What does the court do with that failure to include the uptick in price in the written contract?
It requires you to go back and clarify that this contract had no oral modification clause and both parties were aware of it.
Okay.
So I wanted to clarify that first.
Okay.
And the ultimate decision, the court found that the plaintiff's motion for partial summary was denied. Well, it was denied for breach. And the payment that they tried to give for the basil was not accepted, essentially, correct?
Is that correct? What did the court, so let's, what was the primary dispute? What did the court have to figure out? What was the primary issue that the court had to get to in Mama Rizzo's Pizza? Ms. Dunlap.
I'm so sorry. I was having time.
Anyone?
What the price was.
Whether or not
Whether or
oral
not-
modifications can be made.
Okay, wow, that was awesome. Okay, let's go with Ms. Cope.
Whether or not oral modifications to a contract can be made or enforced.
Okay,
If this was a valid modification for the basil leaves?
okay.
Same thing, whether these particular oral modifications were valid.
My torts professor in law school would ask 50 of us what the issue was. And then would never say yes or no. We'd all have 50 issues on the table, and then you just go on to the, not my favorite professor. So at the end of the day, really, again, Ms. Nelson?
What was the cost of the basil? I think that's what they were disputing.
Okay. Mr. Vaughn?
Says here, the first two cases, primary question, whether contract modifications must be supported by new consideration and when they will be vulnerable to offenses of duress or bad faith.
Okay, Ms. Tollett, really quickly, the pre-existing duty rule, what is it? Pre-existing duty rule?
It's that there needs to be new consideration for the modification?
Okay, if you make a modification, which the courts support, there needs to be new consideration. You can't renegotiate for the same performance, right? Pre-existing duty rule. Okay, Mr. Vaughn, read again. Where were you?
Page 779, first part of the notes and questions. First sentence. First two cases in this section, the questions are whether contract modifications must be supported by new consideration and when they will be vulnerable to the defenses of duress or bad faith.
In Brookside Farms, however, the important question is whether a contract modification must be in writing to be enforceable. 2209(3) of the code provides that requirements of the statute of frauds section of this article must be satisfied if the contract as modified is within its provisions. Many courts have held not only that a writing is required when the modification brings an oral contract within the statute, but also that all modifications must be in writing whenever the contract was within the scope of 2201 originally and remains within the statute of the change. That's why this case is difficult, because it deals with oral modifications, the statute of frauds, and ultimately, I think that the statute of frauds was an issue that was brought up sua sponte by the court. Am I right in that? Wasn't even something that the parties contemplated on a going forward basis. Okay, so let's get some general rules on the table, and then what does the court ultimately say about oral modification and the Basel prices in this case. 776. Thus, top of the page, an oral modification would itself form a binding contract in the absence of the statute of frauds. Considerations can be binding on the parties to a sale of goods over 500 insofar as specific goods have been received and accepted. The court finds that a valid oral modification of the contract between MRI and Brookside occurred on both estoppel and statutory grounds. As stated above, it is undisputed that the parties agreed to alter the purchase price of the Basel leaves. On each occasion, MRI issued separate purchase orders, and Brookside filled each order and invoiced MRI on the price. In each case, MRA paid the invoice price without protest. At the time the first price modification occurred, MRI's vice president and Brookside's general partner discussed whether or not they needed to redraw the contract to account for the price changes in light of the fact that the contract did not allow for oral modifications. It is undisputed that MRI's vice president assured plaintiff that he would make a notation of price changes on MRI's copy of the contract and that this notation would be sufficient. And then finally, skipping down to 776, last paragraph, based on these actions, the court finds that MRI cannot now invoke the no oral modification clause of the contract to bar plaintiff's claim that a valid modification occurred in this case. To do so would be to reach the inequitable results of thousands of dollars could change hands over an extended period of commercial dealings between the parties, during which the defendant knowingly and willfully refrained from acting on the promise that induced the plaintiff to continue shipments and then object to the course of dealing only when it had issued a bad check. Okay, so what does all of that mean? Ms. Daniel.
Well, you can't accept an oral modification for a long time and then when your check bounces, change your mind about it.
Mr. Wessel?
What do I think it means?
Yep.
I mean, I think that even with this private statutory frauds that they've created in this contract, it's still defeated by one, goods being received and accepted. And the court also argues a couple other things as well. So they argue promissory estoppel theory, and yeah, those two.
Mr. Batista?
For this situation, they had, unfortunately, Brookside Farms had, and that's one of the questions I have, is there's this kind of element of detrimental reliance by Brookside Farms, and if you remove maybe that detrimental reliance and estoppel, would it still hold this case as such? That might be too much of a sidebar, but
What are we to make of the no oral modification clause? Is it upheld in this case?
It's kind of like it was waived.
Yeah.
Because both parties took advantage of, or ignored the no oral modification clause to get what they wanted.
Was it supposed to be an oral modification? I mean, so we're talking about a price, right? We're talking about basil leaves and stems and We're talking about new circumstances. So we're talking about an agreement, right? An oral agreement to pay more. Was it supposed to be an oral modification?
No.
Why do you say no?
They were supposed to go add it to the original contract.
Okay, so one of the parties was supposed to go add it to the original contract. Write it in by hand. Agreed to do that, right? Is that Mama Rizzo, MRI's lawyer? Sorry, not lawyer.
Vice President.
President, right? I'm gonna go write it in. So it was supposed to be written in, and yet it's there that the same individual that was gonna write it in tries to rely on the no oral modifications clause to get out from owing the additional monies, right? So it feels a little bit like unclean hands. Feels like someone trying to take advantage of the no oral modifications clause. Maybe Mr. Street, but someone situate this case in the context of the general law we described earlier. No oral modifications clauses are disfavored under the common law, not respected. Oral modifications are expected and upheld under the UCC unless there's a no oral modifications clause. Someone situate the law we described at the top with the holding in this case. You want to do that, Mr. Street?
Yeah, I think the point here is that Texas doesn't follow the majority of states' opinion on oral modifications, and that A, this wasn't supposed to be an oral modification, B, Texas is not following everybody else on how they treat oral modifications, and C, since there was no oral modification clause, and this falls under statute of frauds, it's not, they accept the oral modifications. And since both parties agreed.
Okay, Mr. Bates?
Seems more like these are just exceptions to the general rule. The UCC will uphold no modification clauses except in these circumstances.
Let's go.
I feel like it's not that they will necessarily be upheld, but they will be more so considered whenever these situations arise in court. So like not that the no modification clauses will always be binding, but that the court will consider them more so than they would with the common law. So I think it's kind of like everything with contracts, like there's a rule, but how often is that rule applied? As straightforward as it's worded in our restatement. So I think that it's just considered more with the UCC than with common law.
Okay, we have 1 minute. So if we have time for a last question from Ms. Dunlap. And it looks like third-party beneficiaries are happening on Wednesday. Although I'm tempted in my minute to introduce them and get into it, but Ms. Dunlap, what's the final result? What's the final result for MRI, Mama Rizzo's Pizza? What does the court do finally? And I feel like this is pretty severe and significant, but what's the final holding?
The court found that the no waiver clause, well, I'm reading from page 781, where it says that the court finds that the no waiver clause to be overcome in the same manner that the statute of frauds may be overcome in actual, in addition to the first full paragraph.
Yeah, so the point I'm trying to make is really quickly at the bottom of 778, the MRI is liable to Brookside for the $20,000 in payment, but then it goes on and in 779, I feel like this is significant, bottom of the first full paragraph, having already decided that plaintiff's price increases were legally justified, the court now finds that for the same reasons articulated above, Brookside did not breach its contractual obligations, that MRI is liable for a material breach of its obligation to purchase a total of 91,000 pounds of basil. They got to pay for all of it. Consequently, plaintiff's motion for partial summary judgment is granted on this point as well. Okay.